I would like to briefly introduce this afternoon's keynote, Barbara von Rütte. It's a pleasure to do so. I'm happy to welcome you here this afternoon in the name of Sigrid Köhler and all of us. Barbara von Rütte is a law studies fellow. She is an attorney of law at the European Institute of the University of Basel. She studied law with a specialization in international and European law, migration and mobility studies in Bern, Leiden, and Neuchâtel. Her dissertation just last year, The Human Right to Citizenship, From State Privilege to Individual Right. She was a visiting researcher at Max Planck Institute in Göttingen, as well as a visiting lecturer at the Free University in Berlin. Her research interests, I just name few: citizenship and statelessness. So again, Arendt maybe a reference there. Belonging, discrimination, and democracy. Swiss and international migration law, international human rights protection, and international law, constitutional law, and general administrative law. You do have published quite a few articles on these particular topics. I do not go into this in further detail. I just mention your current research project, which is entitled Legal and Digital Identity, Citizenship for the 21st Century. Welcome, the floor is yours.
So thank you very much for the invitation to speak at this conference. Thank you very much for this very kind introduction. Maybe first a note on language. I will speak in English. I was thinking yesterday whether this is some form of ritual to signal belonging to an international academic community. But anyway, I'm happy to take questions in German and answer them in German later on. So what I will do today or now is to probably break things down a bit after this morning session, even though on this graph, this chart, the belonging in capital letters was on top. But this is basically the more concrete legal ordering of the world and persons and belonging that I will speak about. And if we look at the description of this panel in the program, it refers to Hannah Arendt and to Butler. But I think what it tries to do is to show that that rights and belonging are linked, that the relationship between rights and belonging is somewhat circular. You need rights to belong, but you also need to belong to have rights. So in my input now, I would like to develop this question of this relationship between belonging and rights. And I will do so at a specific example, and that is the example of citizenship or nationality law in the case of Switzerland. Now, the Swiss nationality law is the nationality law that I know best, but I also believe that it's interesting for a German and international audience because there are parallels. And what I'm going to point out is not unique to the Swiss situation. And maybe because I already used both words, a note on terminology. I will use citizenship and nationality interchangeably. I'm very happy to discuss this later on in the discussion. I will not go into details here, but there would be a whole story to tell about these two terms. also within law, but then if we open up the disciplines, obviously it gets even more complicated. But for now, I'm going to use the two terms interchangeably. So short outlook on what I will speak about. I will first briefly elaborate on the relationship between belonging and law. Then in the second part, I would like to set out how I see the links between citizenship, human rights, and belonging. And then the third part is my main part, where I look at this case study of the Swiss nationality law and try to show lines of exclusion or lines where belonging is negotiated. And I would argue that these lines of belonging are often tied to lines of or characteristics of gender, of religion, and of race. And finally, I try to sum it up in a conclusion where I will argue that we, on the basis of human rights law, have done away with most formal exclusionary features of belonging in nationality laws, but that still many lines persist and that belonging is still conditional. So what's the relationship between belonging and the law? I would like to draw here on Margaret Davis' definition. Margaret Davis is an Australian legal scholar, and she defines, or she writes that, and I quote, "Law defines spaces of insides and outsides, and in many respects, law is a large-scale exercise in social line drawing. Exclusion is widespread and seemingly fundamental to law." Now, to illustrate this a bit, I mean, when does a contract apply to a certain situation? When does it not? If you buy a property, are you allowed to build on that property? Does the property fall within a construction zone that allows building or not? Does a certain conduct give rise to a criminal sanction because it's considered to be a criminal act? Do I need a visa to travel somewhere or do I not? These are all lines of inclusion and exclusion. It's social line drawing, as Davis says. And it's not necessarily problematic as such. But as Davis also points out, and I read the second quote here on the slide, importantly, the inclusions conventionally practiced by legal theory are not politically neutral, but conspire to reinforce various social exclusions under the name of objectivity. So it's exactly this question of objectivity, political neutrality, and the legitimacy of line drawing that I would like to talk about today, and where I argue that this deserves our attention when we speak about belonging and non-belonging. So obviously I'm also going to speak or quote Hannah Arendt and her very famous phrase of citizenship as the right to have rights. For Arendt, or at least from what I understood from Arendt, she means by this right to have rights the right to live in a framework or in a setting where one belongs to an organized community. Only such a right to belong, and there she clearly speaks under the impression of the horrors of the Holocaust, only when one has such a right to belong, one can receive protection in the face of totalitarian regimes. Human rights, by contrast, remained an empty promise. They failed to offer the protection needed, despite the promise of being inalienable and universal. So she writes, and I quote, "Something much more fundamental than freedom and justice, which are rights of citizens, is at stake when belonging to the community into which one is born is no longer a matter of course and not belonging no longer a matter of choice." So we again see the circularity of rights and belonging, or maybe in Arendt's conception here, it's rather a conflict or a dichotomy between rights and belonging. Only when we belong do we have the rights that are actually necessary to be protected. International human rights law has a different understanding. In the Universal Declaration of Human Rights, adopted in 1984, Article 2 says everyone is entitled to all the rights and freedoms set out in this declaration. So again, we see that the universality human rights apply to every human being by virtue of being human. There is no need to belong to a certain group or country or nationality for that matter. So states have to respect the rights of every human being within their jurisdiction, no matter their nationality. And individuals can claim their rights against any state that threatens to violate them. No. Here. Yeah. But somehow the drafters of the Universal Declaration of Human Rights were kind of aware that we do have a problem with nationality and citizenship. So they included an article in the Declaration that codifies a right to nationality. I think this must be seen in the historical context of World War II and the very large number of stateless persons that were there after the end of the war, and where everyone agreed that this was a condition that is not acceptable. So we see here Article 15 granting that everyone has a right to a nationality and that no one shall be deprived of his or her nationality nor denied the right to change that nationality. However, the Universal Declaration of Human Rights is not a binding instrument. It's a declaration, but there are the binding human rights treaty that were adopted afterwards. And in these binding human rights treaty, the right to nationality is not included, at least not in such a general manner. There are traces of a right to nationality for children, for example, or there are prohibitions of discrimination in regard of nationality. But there is no general right to nationality. In that sense, states were very careful to give up any of their privileges or to grant any rights when it comes to determining who belongs to the citizenry, to the demos, and who not. So today we still have, according to estimations of UNHCR, roughly 10 million persons worldwide who do not have a nationality. And I mean, obviously, this campaign image of UNHCR global campaign to eradicate statelessness by 2024 is perfect for this conference, right? I belong. It reminded me of also the introduction to, or the first part of this morning session. I belong to the world. Stateless persons may not belong legally to any country, but they belong and they should be recognized as belonging. Now, the campaign was not, it had some successes, but they clearly will fail to eradicate statelessness by the end of 2024. The number of stateless persons is still large and is still growing. But I will not go further here. No, I wanted to make one point because I promised Jonathan that I will bring back every one of his three individuals that he mentioned. So this would be the first one, Pavel, right? I asked Jonathan over lunch just now whether he knew whether Pavel actually was stateless at some point, because in his biography we see how statelessness can arise. He was born to a German father with a Russian mother, so we have, that's what I will come to next, the gender dimension, who actually gets to transfer nationality from a parent to a child. Then, or the other way around, then he lived in Russia, which, or at that time the Soviet Union, which later on collapsed. And the collapse of states obviously is a reason for persons to become stateless. So in addition to the questions of belonging that Jonathan pointed out, yesterday, I would add from the legal perspective that in his case, we see the question of statelessness and legal belonging. But now let me move on to Switzerland and Swiss citizenship law. Why is Swiss citizenship law interesting to talk or to mention as an example when we speak about law and belonging? Switzerland is a migration country, an immigration country, even if that's politically not always as uncontroversial. But 25% of Swiss citizens have dual nationality. 25% of the permanent resident population has no Swiss citizenship. That's 1/4, it's a lot. 20% of that quarter belongs to the second or the third generation. So the parents or the grandparents or even beyond immigrated into Switzerland. And we see here obviously that this has to do with nationality law. Switzerland has a very strong jus sanguinis, so nationality is passed on from the parents to the children, and there is no way to acquire citizenship merely on the basis of being born there, even if it's in the 10th generation. So other than Germany, who did the reform of German nationality law, Switzerland still has an almost exclusive jus soli, leading to huge exclusion of migrant or former migrant populations. The criteria for naturalization to acquire Swiss nationality by application are very high. So the naturalization rate, overall is really low with 2%. So in a European comparison, that's low. In European average, you would have 3 in the restrictive countries, up to 7 in more liberal countries. And with a revision of the Swiss Citizenship Act in 2018, the numbers dropped even more, so by 15% over the last 3 years. That's, in a sense, the background or the political situation. But now back to the law. I said that Switzerland has a strong jus sanguinis, a strong law of the bloods. You see on the slide Article 1 of the Swiss Citizenship Act, which states, well, who acquires nationality at birth. So you acquire it by descent from your mother or from your father, whether they're married or not. If the parents are not married and only the father is Swiss, he has to recognize the child. But that's it. The provision now, today, has no formal discrimination in it. But this was not always the case. Just as in many other states, Swiss nationality law was or included gender discriminations until 1992. So then men and women did not have the same right to pass on their nationality to their children. There was this principle of unity of the family, the idea that, well, one family should have the same nationality, right? Otherwise, if you cross a border, this could get troubles. And at the same time, dual nationalities, or the idea of having 2 passports, was not accepted. Switzerland was not unique in that. That was a worldwide tendency. So the solution to that was, well, it's the nationality of the father that determines, or the man, the husband, that determines the nationality of the children and of the woman. So the woman's nationality followed that of her husband. If she married a foreigner, she would lose her Swiss citizenship. And if a Swiss man would marry a foreign woman, that foreign woman would automatically acquire Swiss citizenship, vice versa. So here I can make another link to yesterday's discussion. So where do we have a situation where someone gets more German or more Swiss abroad? So this would be a case if you would have a Swiss person, or if you had a Swiss man up until the 1990s living somewhere in Latin America, marrying a woman an Argentinian woman, she would automatically acquire Swiss citizenship, no matter whether she had any actual ties beyond that marriage to Switzerland, whether she actually ever lived in Switzerland. So again, this is a very strong expression of this jus sanguinis, the bloodline, which follows the patrilinear line. How was that motivated, or how was that discussed? And I included here a quote from the message of the Federal Council, so the government, the Swiss government, from 1951, on when the former Swiss Citizenship Act was discussed in Parliament and introduced. And the government writes here that, and I added the translation, essential from the Swiss perspective is that the unity of citizenship in the family is safeguarded if a Swiss family is concerned. If the husband and father is a foreigner, hence, if the family is not a Swiss family, it does in any case not depend on Swiss law whether the citizenship of the family is unified or not. So clearly the Swiss family is the family of a Swiss man. And to Switzerland belongs the family of a Swiss man, but not of a Swiss woman. This led to drastic or catastrophic situations. And I have included here a quote from a judgment of the Federal Tribunal, the highest court in Switzerland, from 1946. And it concerned a Swiss woman who had married a German of Jewish religion before the war. And her man lost his German citizenship. And she had previously, with the marriage, lost her Swiss citizenship. So the man was stateless, and with the man, the woman was stateless. And she applied for Swiss, or for reacquisition of Swiss citizenship. And the Swiss courts were faced with the situation that, well, we agree that statelessness is not something good. We don't want any stateless persons. But what did it conclude out of this? And the ruling is really striking. Well, it says, well, the differences made in German nationality law based on racist arguments are not compatible with feelings of justice, as they are in contradiction to the principle of equality of men and violate in an intolerable manner the idea of equality before the law. So here the Swiss court speaks about German nationality laws during the war. And it says, provisions making such differentiations are not applicable in Switzerland and should, in principle, be sanctioned by Swiss authorities. Hence, according to the law applicable in Switzerland, the husband has not lost his German citizenship. So the court says, well, Jewish man, go back to Germany and tell them this was all unjust and give me back my German citizenship. And the woman should go with him. And so it's not a Swiss family. It's a German family. And Germany has to solve the problem. So this was the historical part where we have these blatant, obvious discriminations and lines of exclusions. But we still have them today, and I put down Article 12 of the current Swiss Citizenship Act, which lists the integration criteria that one has to fulfill to apply for Swiss citizenship. And it's funny because it really lists points that we have been talking about the last 1.5 days, right? The first criterion is observing public security and order. You may not be criminal, you may not be an outlaw. You have to respect the values enshrined in the liberal constitution. I'm going to come back on that. You have to be able to communicate in a national language. But this is also interesting. Keep in mind that Switzerland has 4 national languages. As a Swiss citizen, you can easily move from Geneva to Zurich without speaking any German. No one will ask you about it. In the naturalization procedure, you will have to have knowledge of the language spoken in your place of residence. So language works as a line of belonging and exclusion here. You have to participate in economic life. So here we have the criterion of class or property. You have to be able to cover your expenses for you and your family by income or by wealth. And the last point, you have to encourage and support the integration of your wife and or your husband and your family members. So I would like to illustrate that on the basis of two examples, again, two cases. The first one deals with a Turkish woman, the naturalization application of a Turkish woman, which was rejected because she was found to be insufficiently integrated. She was a housewife, she stayed at home, she had her social circles, which were with the Turkish diaspora community, and so on. And her application was refused, and she complained, well, this was a discrimination on the basis of her belief. And the court found, no, well, the fact that she remains within the circle of her family and her fellow female Turkish citizens of Muslim belief and does not get in touch with the local population must be interpreted as a lack of integration and an insufficient will to integrate and to approximate to Swiss culture and the local habits. This has nothing to do, or not directly something to do, with her religion, but, and then the court says, well, it's an expression of the conviction that persons who are distant from the Swiss society and deliberately and voluntarily do not want to get in closer contact with the people of the host country should not be naturalized. All these claims, taken in isolation, are neutral and do not indicate any discrimination based on religion, race, or origin. So here we are again on the first slide by Davis. Are these lines really politically neutral? What is this image of the family and social contexts that we have here in Swiss nationality law? So what's the kind of image of the family that we see and that we expect from someone to belong? In the other case, and this is also something that is obviously discussed all across Europe, is the headscarf. And here the naturalization application was rejected because the woman was wearing a headscarf, and that was pretty clear from the fact. So the court here ruled that this was discriminatory. That here an explicit line had been crossed, right? The wearing the headscarf was the reason to exclude her. And the court notes that wearing a headscarf by itself cannot be seen as a manifestation of a religious belief that would in a generally recognizable way signal an attitude of subjugation of women to men and the degradation of women. So the decisive point where you could exclude is if it were a violation of liberal values, if the wearing a headscarf could be equated to believing or having values that equal a degradation of women. So the headscarf alone is not something that justifies exclusion from Swiss citizenship. An interesting theoretical approach to analyze this, but I'll be brief here, is I think the theory of feminationalism developed by Sarah Ferris, a British scholar, and she argues or identifies the role of the woman as the mother and the embodiment of the nation, and that's why this control of cultural values and liberal values is important because she, the woman as the mother, passes this on to the children. But I would like to move on to my last example of line drawing in Swiss nationality law, and that is the case of denationalization or deprivation of citizenship. This is a practice that re-emerged after 9/11 and the Paris attacks all over Europe, not only in Switzerland, but in several states. And it's today mainly done with regard to so-called foreign terrorist fighters, so persons joining ISIS, mainly in Syria, where the states have the feeling that we need to have some instrument to safeguard national security, but also to punish this kind of conduct. And the Swiss Citizenship Act did introduce a provision to revoke citizenship already during the war, and this provision was kept in the law until today. And after a period of almost like 70 years after the war, when no one was deprived of their citizenship, they started to make use of the provision again in 2015. So, what are the conditions? A person's conduct has to be seriously detrimental to the interests or the reputation of Switzerland, and the person may not become stateless. So it's only dual nationals who can be deprived of their citizenship. That's the kind of human rights lower bound. You cannot strip someone of their citizenship if they would become stateless. And then this question, what is actually conduct that is seriously detrimental to the interests or the reputation of Switzerland? This is then defined in an ordinance to the law. It applies to serious crimes in the context of wars, war crimes, then terrorists, and then damaging the reputation of Switzerland or diplomatic relations, even though it's clear that in the current context, terrorism is the prime example. And technically, you would need to have a final criminal sentence, but there is a provision in the law that this final criminal sentence that proves that you actually did this crime is not necessary if the conduct occurred in a state where criminal prosecution is not possible or where the state is not willing to do so. And this is clearly also the Syria example, where you have territories under the control of ISIS which are not willing or able to prosecute or to do a rule of law based criminal procedure as expected in Switzerland. So this is kind of the legal context. And this is the first case. This is the headline from Blick. Blick is the Swiss equivalent to the Bild-Zeitung, so the big tabloid. And, well, it's very, yeah, well, I think there's a lot to unpack. There would also be a lot to say from a legal point of view, whether it is proportionate, whether the justification is sufficient, whether it actually serves the purpose that it's supposed to be. But I would like to focus here on a few points that I find interesting. So the case concerned Swiss-French dual national who grew up in Geneva and radicalized there and then left for Syria with two children, two minor girls who also have Swiss citizenship. And there she married, I think, a Dutch, also foreign fighter, had another child with him. And then at some point she wanted to return, and Switzerland refused to let her come back and instead opened this deprivation procedure and then stripped her of her Swiss citizenship. Now, we don't really know what she actually did. This is classified information for national security reasons, but also there was no criminal procedure against her in Syria. She's still in a camp controlled by the Kurds. and the fathers of the two older girls would like to get their girls back. So it's politically also, or more of a child rights perspective, it's a very difficult situation. The girls are still Swiss, they would like to come back. The Kurdish forces say we only let go the entire family and not only the girls, and Switzerland does not want to take the entire family back. But what I find interesting also is this question of loyalty. Aren't we reminded here of the situation that the nationality and the belonging of the woman follows that of her husband, and that in her case, the question what she actually did is less important compared to other cases where we do have images of foreign fighters that actually committed war crimes in Syria. And I think we can also recall Mohammed Ngum here that we heard of yesterday, and the question, well, what is extremism and what does that have to do, or how does that occur in a person's biography? And in her case, obviously, what does that have to do with her belonging to Switzerland? She radicalized in Geneva. She lived in Geneva. She did not live in Syria. She's not a Syrian national. She's a French and Swiss dual national. So doesn't she belong to Switzerland? And isn't she kind of, despite whatever horrible, horrible acts she might have done, I don't want to in any way question the horrible nature of terrorism, but isn't she still Swiss? And I think we can contrast this with this guy. So if Miss F, from the previous slide, is Mohammed, then this guy here has certain similarities to Albert Cook. He's a Guatemalan Swiss dual national whose, I think, grandfather emigrated from Switzerland to Guatemala. He was the police chief of Guatemala City, and in that function was involved or led a raid in one of the biggest prisons in Guatemala City, where it came to several deaths, or numerous deaths. So he was confronted with criminal persecution for grave violation of human rights in Guatemala. And he used his Swiss passport, came to Switzerland to avoid extradition to Guatemala. As a Swiss citizen, you cannot be expelled to another country. So, and we know that in that case, the Swiss authorities briefly discussed, well, would that be an opportunity? Could we deprive him of his Swiss citizenship, given that he used that citizenship in an abusive manner to evade criminal prosecution? But they ultimately decided to take a different path, and they tried, or they did a criminal prosecution in Switzerland, and he was sanctioned to 15 years of prison in Switzerland, and is now in prison in Switzerland 2 years ago. So we see here that in case of these deprivation cases, there would be different means to sanction persons, and I think the question of belonging obviously comes into play when we ask ourselves, does he actually belong to Switzerland? He never lived there. He doesn't speak the language. He was in Guatemala in second or third generation. So again, the lines of belonging are negotiated differently. So to come to a conclusion, what I want to illustrate with these stories is that law, as Davies says, does this slide drawing, and that we need to be aware of the underlying political, cultural, and social factors that influence this line drawing when we speak of belonging. So human rights, and in particular the principle of non-discrimination, has helped us to address blatant, obvious forms of discrimination and exclusion and lines that are not acceptable. But still, many lines of belonging and non-belonging persist. And I would argue that we have to continuously ask ourselves where we draw these lines of belonging and exclusion, and that we have to make sure that they don't overlap with powerful markers of social exclusion. Thank you.